On my orders, coalition forces have begun striking selected targets of military importance to undermine Saddam Hussein's ability to wage war.
March 19, 2003, George W. Bush announces the beginning of the U.S. escalated involvement in Iraq. March 20, 2003, protests against the war in Iraq sweep the globe. In Chicago, more than 18,000 people took to downtown Chicago to protest and marched with police permission on Lakeshore Drive, a 6-lane highway adjacent to downtown Chicago. The protest blocked traffic for hours and drew national media attention. But police blocked the protest at the intersection of Michigan and Oak, blocks from the protest's intended completion. At that point, Chicago police, for some reason, changed their approach. Where previously police had assisted protesters, directing protesters and traffic, to instead engaging in violence and mass arrest, the largest mass arrest in Chicago history, in fact. Some 860 people were arrested, including passers-by who had nothing to do with the protest. Some were held in jail for up to 2 full days. More people were arrested in just one evening in Chicago on March 20, 2003, than were arrested in a week at the famed 1968 Chicago protests of the Democratic National Convention. That March 2003 protest didn't just mark the beginning of a war. It also marked the beginning of a saga in the courts, for justice and for freedom of speech and freedom of assembly, a saga that continued well after the war in Iraq officially ended. April 2003, attorneys for the Chicago chapter of the National Lawyers Guild won dismissal of all charges against arrestees, which ranged from reckless conduct to not even being charged at all. That same month, attorneys with the National Lawyers Guild, representing some 500 arrestees and detainees, filed suit against the city of Chicago and the Chicago police to bring a measure of accountability for all of the spurious arrests, detentions, and prosecutions. April 17, 2006, United States District Court Judge Virginia Kendall finally grants class certification to the lawsuit named Vodak v. City of Chicago, more than 3 years after it was filed. In response, the City of Chicago took the unusual step of countersuing the demonstrators, claiming that protesters had to pay for police and other costs incurred as a result of their protest, quoting a portion of the municipal code. An attorney with the National Lawyers Guild responded back, quote, "This is the first time that this ordinance has ever been used in a situation involving First Amendment rights and a peaceful protest. It's a very, very sinister thing to happen if they can go through with this, because maybe people will be afraid to demonstrate and their rights will be chilled if they have to pay for police services," unquote. March 12, 2008, that same judge, Virginia Kendall, effectively blocked that police countersuit, rejecting an attempt to have its suit certified as a class action. Later in 2008, a Freedom of Information Act request with information dating back to 2006 found that the city had spent more than $2 million in actions against the Lakeshore Drive protesters. That, with at least $1.5 million in funds known before 2006, means that the city spent more than $3.5 million, a figure that has almost certainly grown since 2008. In 2010, right before the class action suit by protesters came to trial, the city had won a summary judgment against the class action. The trial judge dismissed the lawsuit, claiming that the police and the city were not liable for First Amendment violations because the detentions and arrests were deemed reasonable. March 17, 2011, the Seventh Circuit Court of Appeals, based in Chicago, agreed with protesters and found that the trial judge wrongly dismissed the suit. Judge Richard Posner found that attorneys had presented sufficient facts to establish the need for a trial, including more than 250 affidavits from anti-war protesters, and the suit was reinstated. The court strongly criticized the city of Chicago for its maltreatment of demonstrators, and dealt a severe blow to the city's attempts to sweep the lawsuit under the rug. What's more, the ruling affirmed that the city cannot arrest peaceful protesters without warning, even if such protesters don't have a permit, and that this requirement will hold for all future public protests. Chicago's new mayor, much like his predecessor, has not shown much love for Chicago political activists. But with the NATO G8 summit coming to Chicago in May 2012, and with tens of thousands of protesters slated to arrive for the summit, this suit was a sword of Damocles over the city, and a possible trial, if badly timed, could inflame the ire of protesters further, and perhaps deal the city a financial loss of historic proportions. It would make sense for the city to cut their losses and settle, and that's what happened. January 19, 2012, corporate media in Chicago reported that 16 Iraq War protesters arrived at a settlement with the city of Chicago for an undisclosed financial sum. February 9, 2012, almost 9 years after the protest which spurred the lawsuit, a settlement was reached on the 2003 anti-war class action lawsuit. The city agreed to pay a total of $6.2 million to compensate more than 700 members of the class. Individual members of the suit would be compensated depending on the degree of constraint they faced. Those detained for over 90 minutes will receive up to $500. Those arrested but not charged will receive up to $8,750. Those arrested, charged, and required to go to court will receive up to $15,000. It's not likely that those arrested on March 20, 2003 thought that they would see a resolution to their action nearly a decade later. But effective political activism is seldom quick, and wins that seem to occur quickly often in retrospect emerge as the result of a lot of effort over a long time. But it's a testament to the hard work of the attorneys and the activists who continue to fight for peace, freedom, justice, and civil liberties. It's a story that should inspire us all.